Hello, and welcome to the CalTAP Veteran Cultural Competency Training for Attorneys, brought to you by Swords to Plowshares. If you have not viewed the general Veteran Cultural Competency Training provided on the CalTAP website, we strongly encourage you to do so now, as it provides a foundation for the following material. Being aware of prior military service can inform how attorneys interact with their clients, understand their history, marshal evidence on their behalf, and shape legal strategies for them. So first, a disclaimer. This is not substantive legal education. Instead, it's a primer, it's a broad overview of cultural issues and also some different state and local programs and how the law can be a little bit different for veterans and their families. There are a number of excellent CE accredited legal trainings for substantive representation of veterans, and you'll find them on the website and referred to throughout this training. So the state of California is home to more veterans than any other state in the nation. And the legislature recently directed the state bar to administer a program to coordinate pro bono civil legal assistance to veterans and their families who otherwise cannot afford legal services. They've been conducting outreach and assessing what sort of legal assistance is out there. And you can find more information on the State Bar website on their Veterans page about their findings and what opportunities are out there. In the state of California, we have Military Form 100. Veterans can complete this form, share it with judges and attorneys to alert them of their veteran status. Now, this can open up potential eligibility for benefits and protections. It can also have serious impact on their legal situation. So consideration for alternative sentencing, diversion, and additional time in family law cases. So we'll start off talking about employment law. USERRA, or the Uniformed Services Reemployment Rights Act of 1994, provides protections for Guard and Reserve members who are called away from civilian employment to go off on deployment. If they give proper notice before and after deployment, these service members can return to work and retain all the benefits and employment status as if they had never been away. Veterans, of course, have ADA protections for discrimination based on disability. That said, employers may ask about disability status for affirmative action purposes, and there are a lot of incentives for certain employers to hire service-connected veterans, so it can be an important part of getting a job. When we look at other aspects of discrimination, I want to look closely at PTSD and assumptions and myths that are out there about veterans. So remember, of course, discrimination can be based on real or perceived disability. And there are a lot of myths that veterans all have PTSD, they all were in combat, etc., which of course is not true. So you can think about that wrinkle when you're representing those veterans. The Vietnam-era Veterans Readjustment Assistance Act of 1974 provides some protections for service-connected veterans. It makes it illegal for companies to discriminate against protected veterans. These companies which do business with the federal government, so federal contractors, in some cases state contractors, have to take steps to recruit, hire, and promote protected veterans. This can include a wide swath of employment fields: construction, IT, banks, manufacturing, accounting firms, the list goes on and on. There are some issues where family law is different for military personnel. Some of the important differences don't lie with the law, though. They lie with the cultural experience of being a family member. Families move with their military personnel. They may move often. They experience extended separations. Transition after military separation can be difficult, high stress. Children have long absences from their mother or father. And during deployment, service members assign power of attorney, custody, and other decision-making over to someone else, usually a spouse. And with all that responsibility, all of that change comes stressors, unique stressors. When it comes to child custody and spousal support, a history of absence due to service cannot be used against a veteran. That only makes sense. They have no choice about their deployments. VA financial benefits can be counted as income for child and spousal support purposes, but are not subject to levy, seizure, or attachment the way some other sources of income might be. Now, you can go through a process called apportionment when some of those financial benefits may be sent directly to the custodial parent. Finally, VA financial benefits are not considered marital property, but military retirement pay is. Interpersonal and family violence can result from PTSD and the stress of deployments. It's not causative. There are individuals who were involved in family violence before deployment and after deployment. But in some cases, this behavior does only occur after deployment. In these instances, it may be sensible to look at the experience of the veteran and their family and look to a course of treatment rather than incarceration. The Orange County Court has actually taken this step to have a diversion court for these family issues. To date, they're the only court of its kind, and it's very interesting to look into. Turning to criminal law and incarcerated veterans, 8% of the population in our prisons and jails are veterans. Difficulty adjusting to civilian life, economic disadvantages, mental health issues, alcohol and drug are shown to contribute to veteran criminality. California and the nation's criminal courts have responded with a proliferation of veteran treatment courts. These vary greatly from jurisdiction to jurisdiction concerning the types of offenses they'll accept and the processes for diversion and treatment. But when we look again that so much of the criminality can be associated with difficulty with transition, drinking, homelessness, poverty, if we can look to the underlying issues, these veteran treatment courts are very, very effective. California has also adopted a criminal code section for pretrial diversion and post-conviction consideration of a veteran's experience where the individual has mental and behavioral health issues such as substance abuse, PTSD, and TBI stemming from service, and their crimes were committed as a result of that service-connected condition. Of course, this is a criminal code statute, so it's not reliant on the availability of a veterans court. The VA has also established programs to address veterans with criminal justice involvement. Veteran Justice Outreach Workers, commonly called VJOs, conduct outreach to incarcerated veterans and veteran defendants, connecting them to community-based providers and VA services. They also work closely with the court to monitor the progress and success of veterans who are going through treatment in lieu of incarceration. So those representing veteran clients may be asked to gather medical evidence, clinical evaluations. You also have to establish a connection between the action and the diagnosis. You will have to work with the court to arrange for a treatment plan, update that treatment plan as needed, and to make sure that the client successfully participates in that treatment. There are several counties in California that have established veteran pods or veteran dorms within their jails. These include restorative justice models access to VJOs, the veteran justice outreach workers who are going to help reconnect people with services once they are released from prison. They have been shown to reduce recidivism, and we'd encourage other counties to establish such pods. All right, so there are lots of veterans out there who need representation. There are a lot of pro bono opportunities. As we said earlier, the State Bar of California is coordinating some of these opportunities, so you can look at their pages for opportunities for pro bono activities and for education on veteran-specific legal representation. If you want to help with VA claims, there are a couple of different steps that you have to take. You have to be accredited by the VA, and you have to meet minimum CLE requirements. This is very simple to obtain. First of all, be sure to file for the VA accreditation before doing the CLE. You have to complete the CLE within 12 months of applying for that accreditation. But good thing is there is free and very good legal education out there. The Practicing Law Institute has excellent training, and this will satisfy those requirements, and it is free. Another very important issue, you may not be compensated for claims assistance at the initial stages. You can only do this as a pro bono attorney. So we hope that you do want to help veterans with their VA claims. It can help veterans immensely. It opens up a world of healthcare and financial benefits for them. It can mean the difference between a dignified life and living on the streets, especially for poorer veterans. So, what is service connection? It is any injury or illness that occurred or was exacerbated during active duty service. It doesn't have to be related to the duties of service or combat. It doesn't have to have happened during, quote, work hours. It's anything that happens during that entire span of time that the veteran was in service. So that can include things like manifestation of schizophrenia. Often that develops in the early 20s. That happens to be when young people are in the service. It can be cancer. And of course, it can be things that are very associated with military service like PTSD or physical injury. Also, secondary conditions which occur because of that initial service connection can also be service connected. This can increase the disability rating, which can increase the amount of money, financial assistance that veteran will get. It can also increase and open up access to things like aid and attendance or caregiver benefits. So an example of that would be your client has PTSD. 20 years later, they develop heart disease. There's a connection there. You can establish that, and you can increase their disability rating. Now we'll turn to consumer protections. The Soldier and Sailors Relief Act provides protections for people who are on active duty and they are deployed and they don't have control over their finances or some of their contracts at home. Now, many veterans are also members of the National Guard or the Reserves, so it can apply to them when they are called to active duty. Some of the basic protections include interest rate caps on loans, but it can also provide protections with lease terminations, evictions, mortgage foreclosures, and other issues. It also allows for an ability to provide a stay on cases, so it can remain on hold until that individual returns from deployment. The San Diego County Bar Association hosts a pro bono program that assists in these cases, and they also provide periodic CLE training for attorneys specifically for this purpose. Treating clinicians can provide medical evidence that you obviously will need to develop your case, marshal that evidence for your client. Now, that said, healthcare professionals may resist working with an attorney. They may feel that adjudicating a trauma conflicts with their mission of healing the patient, that it exacerbates trauma. So you can overcome these issues by discussing the long-term benefit to the client, the access to care, the benefits, the financial stability, housing stability, how this is going to help the client in the long term, and ultimately also help with their mental health and their physical health. Also, demonstrate your understanding of trauma-informed representation so they know that you understand how to engage in active listening and how to acknowledge the trauma of the client while representing them. All right, so what is trauma-informed representation? Well, trauma-informed care is a framework grounded in understanding of and responsiveness to the impact of trauma. It gives opportunities for survivors to regain and rebuild a sense of control that was lost due to a traumatic event. Now, this is particularly important for veterans. Think about that identity of the military training, of being capable, of being in control. And what is trauma? The complete loss of control, the loss of your identity. So you can help your client rebuild that power through your representation. Interviewing clients who have experienced trauma can be difficult, not just because you're talking about traumatic, painful events, but also because memory is a funny thing. Your clients may actually not remember the details of the traumatic event because they sustained a traumatic brain injury or because the experience was so overwhelming. Memories may change over time. They may come back in fits and starts, arise over time and in pieces. So you really have to work harder to pull that story together, combine it with documentary evidence in order to tell that story. Now, another issue when you're working with veterans who have experienced trauma is the symptoms of their PTSD, for example, for which you are trying to get them help, for example, include avoidance and isolation and disassociation. So the issues that they are dealing with for which you are trying to help them actually can get in the way of helping them. So you've just got to be prepared. And you can work with professionals who know how to do this. There's excellent training. We have right here a guide to post-traumatic stress disorder for advocates. It's an excellent free program that you can watch on PLI. Going back to that loss of power that results from trauma and trying to rebuild that power and predictability and control, that's really going to help you in developing a relationship of trust with your client and to get all the information that you need in order to represent them. So acknowledge concerns up front. Describe what kind of information you need and why you need it, especially when dealing with a traumatic incident, healthcare records, and other sensitive information. Explain what will happen to the information. Explain the timeline, the processes, and the potential outcomes of the legal process, good and bad, of course. Also, make sure you acknowledge with the client that either you aren't a veteran yourself, or maybe you are a veteran but you're not familiar with their particular experience, that you're going to need their help to help you learn what you need to know in order to be a team and to represent that veteran. All of this is going to help you develop a trusting relationship, and that's going to ultimately help you marshal the evidence that you need and provide really great services to your veteran clients. Also, remember that there's lots of education out there and lots of support for you. Representing veterans is incredibly gratifying, and we really hope that you'll include that in your practice Be sure to visit the CalVet website for more information about referrals, about specific medical conditions, about VA practices and procedures, opportunities for more education, and more. Thank you.